Hello all, I Neeraj Kabra on behalf of Law Chamber of Siddharth Morarka. Welcome you all to our new webinar. Today we have speaker, Senior Advocate Haresh Jagtiani sir. He will be enlightening us on today's topic, that is the concept and principle of burden of proof and estoppel and as applicable to civil and criminal trial. Before I hand over to Haresh sir to take over and start with his lecture, there is a question answer session at the end. You can put all your query or all your questions in the chat box. It will be answered by Haresh sir at the end. Thank you. Now I request Haresh sir to kindly take over and start with his lecture.
Good evening, everybody. And once again, thank you for considering me worthy of another webinar. And my topic today is as has been announced, the relevance or the principles of burden of proof and estoppel as applicable both in civil and criminal trials. Now, I have dealt with the subject of burden of proof in my previous webinar when I did it in the context of cross-examination. But some parts of it may be repetitious, but it nonetheless is worth going down that path again, just to put things in some sort of a perspective, because these are all important provisions of the Evidence Act. And this is really the discipline by which a judge must decide the case before him, whether he's sitting in a civil or a criminal assignment. But these are things, and some of these principles are common to both these jurisdictions. Now put yourself in the position of a judge. How would you decide a case? What would weigh in your mind? Now I know probably some of you are tempted to say that I will decide it in favor of the prettier lawyer. Frankly, if I were a judge, I would probably use the same yardstick. It's so much easier that way. But maybe that's the reason why nobody has offered me judgeship. But jokes apart, the judge's task is fairly unenviable in that respect, because he has to follow a certain discipline. He can't get carried away by prejudices. And when a case is presented to him, when the totality of facts are before him, he has to decide on the principles which are laid down in the Evidence Act as to whether the person who comes forward with a claim or the person who comes forward to prove his point of view, whether he has discharged that burden in the manner which is contemplated under the Evidence Act. You know, there's an old joke of a new judge who had been appointed somewhere in America, and he had just taken his seat. He was deciding a criminal case and very new to the proceedings. And there comes the prosecutor, the attorney general of that state, and very, very eloquently talks about his case as to how, how the accused should be found. Sorry, just a minute. Just give me a minute. So there's this judge, new judge, who has taken a seat, and the attorney general makes an excellent speech to establish the guilt of the accused. And the judge tells him, so this new judge is so absolutely impressed with the attorney general's address that he tells the defendant's counsel, he says, look, there's no need for you to address me now. You can't possibly have an answer to what he has said. Now the defendant's counsel protests and says, but you must, Your Honor, you must hear me. And then tells him that this is the law. So finally the judge says, all right, go ahead, say what you have to say. And then this defense counsel gives his own speech, and it is even more impressive. And he's absolutely fantastic in his defense, at which the judge says, well, what do you know? Now the defendant wins. So these are some of the impressions which a lawyer can have on a judge. And actually, I have heard a retired judge say, when he was paying a tribute to some of the counsel who had passed on, like Palkhiwala and Ram Jethmalani, etc. And he actually said that when he used to listen to them, he would postpone writing his judgment by a few days, because the impact of their oratory was so strong, was so intense, that he really couldn't wean himself away from that impact. He had to sit dispassionately, objectively for a while, and then reassess the evidence before him. Okay, so much for this, just the impact as to how that can be made by a good and competent counsel before a court. But let's come down to the subject at hand. Now, when you say that the burden of proof lies on a particular person, what is that burden? That burden is a burden to prove facts which constitute the essential ingredients of the claim before him. Like, for instance, a person comes forward and claims breach of contract, claims damages for breach of contract, etc. He has to show that there is a valid contract. He must then show that there is a breach committed by the other side, maybe a wrongful termination, maybe a violation of the terms of the contract, and then he must show that that must result in some damages flowing to him. These are the ingredients, these are the facts that he has to establish. Similarly, in a criminal charge also, let's suppose someone is charged with theft, then the essential ingredients of theft have to be established, namely that someone has taken someone else's property, moved it without his consent, appropriated it dishonestly, and made a wrongful gain to himself. Each of these individual ingredients are the ingredients of an offense, and these are the basic facts which must be proved, whether it is in a civil case or whether it's in a criminal case, to be able to succeed. So the whole issue of burden of proof is that the burden of proof is on that person who has to prove those facts. Now, fact is defined, and there are 2 or 3 definitions which are worth bearing in mind. Fact is defined under the Evidence Act as, fact means and includes anything, state of things, or relation of things capable of being perceived by the senses, and 2, any mental condition of which any person is conscious. So this is a fact. This is the meaning of the word fact. It's all embracing, even a state of mind, even your opinion is a fact. Then the next important definition to bear in mind is the definition of proved. Now, a fact is said to be proved. Now, this is very important. When, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act on the supposition that it exists. Please note the word prudent man. So either the judge himself believes that such and such a fact exists, or he puts himself in the shoes of a reasonable and a prudent man and says, would that prudent man conduct himself on the supposition that such a fact exists? Then he will take that fact to have been proved. Now, please see this. Therefore, the concept of a reasonable man or a prudent man runs through all trials, whether it's a civil trial or whether it's a criminal trial. This is a test. Either the judge himself believes it, or he places himself in the position of a prudent man and says, if the prudent man accepts it, then that's fine. Then that fact is said to be proved. But how would a prudent man behave? If you ask that question, how does a prudent man behave? And what is his understanding of a situation would depend upon the situation of a case. Excuse me. I've given this illustration the last time, but it's worth bearing. A prudent man, if he's hearing a civil case, will tend to accept a person who's making more sense than the other guy, or whose testimony is more credible than the other guy. But the same prudent man, if he's hearing a criminal case, he will say, well, look, the consequences of this criminal trial, if it goes against the accused, will be that man may either go behind bars or he may even hang, depending upon how serious the offense is. In such a case, he says, well, I'm going to be more cautious. If the case is, in a civil trial, it's one thing. I'll say, okay, it weighs in favor of one more than the other. But in a criminal case, I'm going to be very careful. So the same prudent man applies different yardsticks. And last time I had given the illustration of the O.J. Simpson case, which is very, very poignant in a situation like this. Namely, as you know, O.J. Simpson, the great iconic footballer in America, was found guilty of killing or was tried for killing his wife and his ex-wife and her lover. Now the matter went to trial, and the jury came to the conclusion that he was not guilty of murder because they thought that the investigation was imbued, or rather had racial overtones about it. So they said it's not safe to convict him. But the parents of his ex-wife, they sued O.J. Simpson in a civil trial for the same offense, saying that they're liable to damages for the death of their kin. And on the same set of facts, the jury held that O.J. Simpson was guilty of the same act of murder and liable to pay damages to them. Now, the same set of facts gives rise to it results in acquittal as far as a criminal trial is concerned, but results in damages as far as a civil trial is concerned. So therefore, this is it. Now, generally, what is the nature and types of burden that the law recognizes? Again, in some terms of generalities only. First, of course, as you know, that the heaviest burden that lies upon any person proving a case is on the prosecution in a criminal trial, where he has to prove his case beyond reasonable doubt. And again, beyond reasonable doubt doesn't have to be equated with beyond a shadow of a doubt, because there are any number of Supreme Court judgments which say that there is no question of perfect proof in an imperfect world. So therefore, once again, it's beyond reasonable doubt. Now, that reasonable doubt is the reasonable doubt, again, of a prudent man, that whether he would entertain a doubt. Then the next type of burden is that which lies in a civil case, generally, when a person must prove his case on a preponderance of probabilities, which means, having seen the evidence in both the cases, if it weighs more in favor of one and less in favor of the other, the evidence that weighs more in favor of one must succeed in a civil trial. I'm coming to this principle of preponderance of probability. It also has room. It also has to be discussed in the context of a criminal trial. I'll come to that later. And then the third type of burden is the burden which is the converse of the first burden of the prosecution, namely beyond reasonable doubt. And that is where a person the accused person must discharge his burden on a mere probability, on merely probabilizing his case by saying that, look, this is the totality of the evidence. Fine, it may prove my guilt, but also it is not inconsistent with my innocence. And therefore, taking into account the presumption of innocence of an accused person, he, by probabilizing his case, is entitled to an acquittal. There is another type of burden, which I'll just come to in half a minute. The nature and type of burden, and to the extent to which it is to be discharged, is found in some special laws. Now, if a special law decides that this is how you discharge the burden, then you give a go-by to these conventional types of burden that exist. For instance, let me give you an example. Under Section 278 of the Evidence Act, which makes a person prosecutable for, let us say, concealment of income. Now, it says, 278E says, that wherever a mental state is an essential ingredient of the offense, then whether a person has that mental state or not is for the accused to show. Yes, it's for the accused to show that he did not act with a guilty mind or with a culpable mental state. And it goes further to say that burden has to be discharged by the accused in the same manner as a prosecution must discharge its burden in a criminal trial, namely beyond reasonable doubt. So therefore, by special statutes, it may change the nature of the burden. It may change the extent to which an accused person is required to discharge it, but that is by special law. You have a similar provision also under the provisions of the Customs Act, etc. These are usually economic statutes which impose this thing. Now the question is, what this burden of proof for the same offense may vary depending upon whether it is tried in a criminal court or in a civil court. Let me give you an instance. in a case, you might just make a note of this. This is a case from an Australian case. It's a case by the title Helton versus Allen. It's a 1940 High Court of Australia case, HCA case. I don't have the page number, but when I give you my written note, I'll include it in it. Now, what had happened was, the person was tried for the murder of a relative who had passed on and had named him as one of the beneficiaries in his will. Now, he was tried for the murder of the testator, and in the murder trial, he was found to be not guilty. He was acquitted of the charge of murder. Now, if he's acquitted of the charge of murder, then in his will, in the will left behind by the testator, he would be entitled to inherit whatever had been left to him, whatever fortune he was to inherit. One of the relatives of the deceased brought this case against him in a civil court, in a testamentary jurisdiction, and said he is not entitled to inherit because he has committed the murder of the testator. Now, when the jury applied its mind to whether he was guilty of murder for the purposes of inheritance or not, they applied the yardstick of preponderance of probability and not beyond reasonable doubt. So you see, this is very interesting. The same act, the same situation, in the sense, not guilty of murder in a normal case, but when it comes in a civil case, when the same issue is tried in a civil setting, then you apply a different yardstick and a different standard. Now then, the question is, how is this burden to be assessed? Sections 101 to 104 of the Evidence Act lay down general salutary principles as to who proves what. And it is worth reading each of those sections. They're very, very short sections. I'll just read them out and then give you some illustrations and case laws on the subject. Now, section 101 says that provides who must provide what. This is 101 to 104. 101 says, provides that whoever desires any court to give judgment as to any legal right or liability dependent upon the existence of facts which he asserts must prove that those facts exist. So if I want a judgment in my favor based upon certain facts, I must prove that those facts exist. Then section 102 says that on whom the burden of proof lies, it says, provides that the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. So if it's neutral, then the person who was bound to give the evidence and doesn't give it and he must fail, the burden of proof is upon him to give that evidence. Then section 103 says, the burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence unless it is provided by any law that the proof of that fact shall be given by any particular person. And then section 104 says that the burden of proving any fact necessary to be proved in order to enable any person to give evidence of any other fact is on the person who wishes to give such evidence. Now there are two cases, and I request you just to make a note of the citation, and in my note I will fill that in. One is in the case of just a minute. Yeah, Ranganmal versus Kapuswamy, that is AIR 2011, Supreme Court, page 2344. And the other one is in Nagar Palika versus Rameshwar Lal, that's in 2017, 9 Supreme Court cases, page 618. So therefore, these are cases which sum up the burden which lies on a person under the provisions of section 101 to 104. In one case, what the facts were was that a person was in possession of a certain property and that he was sought to be deprived of that particular property by the government of his state by saying that that property actually, because his claim was that I'm in possession of this property and I own the property, as it was a grant given to my grandfather. And so therefore that was his claim. Now the government said that that grant which was given to your grandfather had been revoked. Another land was substituted in its place, and he was refunded some money for the deprivation of that land of his. So this was the case of the government, and this was the case of the person. Now the government failed to prove the revocation of that original grant and that the money had been refunded to him, or some monies had been refunded to him. So the failure of the government to bring these facts on records could not match the fact that he said, being in possession of the property, he would be entitled, the presumption would arise. And that's one of the presumptions also, that if you're in possession of the property, you're deemed to be the owner of the property. So the government failed by virtue of the fact that they had to, if they wanted to succeed, then they ought to have brought those facts on record, namely the revocation of the grant to the grandfather and the refund of the money. Failure to do so under the provisions of 101 to 104, which I read, disentitled the government to dispossess this person, and therefore his ownership remained established. Now then, Section 58 and 58 of the Evidence Act is an extremely important section, which says that if the parties to a dispute agree on a certain state of facts, then that by virtue of that agreement, those facts are established. There's no need to give any proof for that. Or for that matter, if by the laws of pleadings or by the law of any which governs a particular trial, those facts are deemed to be admitted, then no evidence is required to be given in respect to those facts. For instance, as you know, if for instance you make a claim, now under the CPC, you're bound to deny any specific claim which is made by a person. So if you fail to deny that fact or fail to refute it, then by the doctrine of non-traverse, that fact is deemed to be established. So in such a case, there is no need to produce any evidence. An agreement of the parties or the operation of law which deems a fact to be admitted or proved is sufficient, and no need to provide any proof. I'll give you the citation. There's one case which is worth, it's a 1974 decision, AIR 1974, Supreme Court, page 471, in the case of Nagindas Ramdas versus Dalpatram Icharam. Right. Now then, we come to Section 105 of the Evidence Act. Section 105 is extremely interesting. Section 105 applies to criminal trials. What it says is that if in a criminal trial, an accused wants to claim the benefits of an exemption to a particular offense, you know, these exemptions are contained in sections 1 to 95 or 2 to 3 to 95 of the Indian Penal Code. Now, if he wants to claim the benefit of any of those exemptions to an offense, then the burden of proving that he falls within that exception is upon the accused person. So, or if by any other law he wants to claim the exemption from the commission of an offense, the burden of proof is on him to prove that he falls within the exception. Now the question arises, if this burden shifts to an accused person on an application of the principles of Section 105, to what extent is that burden to be discharged? And here, once again, the law is very clear on the subject, and I'll give you some couple of citations. The law is very clear that when an accused is discharging his burden, taking advantage of the exception, then he has to discharge it on a preponderance of probabilities. He doesn't have to discharge his burden on the basis of any higher standard, unless, of course, as I told you earlier, a special law requires him to discharge his burden on a higher level or by a higher degree. So therefore, this is the provisions of this thing. Now, the case on this is, you might make a note of it, is Gang Gogoi versus State of Assam, 2013. That's 5 Guwahati Law Reports, page 612. And this is this judgment is extremely well written. It says, therefore, the burden is on the accused person to discharge it on a preponderance of probabilities, and goes on to say that if on the examination of the totality of the evidence, he is yet able to pick holes and find inconsistencies in the evidence which has been led by the prosecution, then he would be entitled to even the benefit of the doubt on the principle of being able to probabilize his case. Now, Section 106, again, is another very interesting provision. And Section 106, may I just read that out? It says as follows, that burden of proving facts, especially within the knowledge, that is, when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. And there are two cases. I'll give you 2 or 3 cases. I'll just give you the citations right now and then deal with the proposition with some examples. One case is, the first case is, it's an old case, but may I just give you the citation, and then the name is hardly relevant because you'll find it from the citation. AIR 1956, Supreme Court, page 404. Then the other one is 2006, 12 SCC, page 254. And the third one, unfortunately, I don't have the exact citation, but let me now tell you what this principle is as far as the Section 106 is concerned. Now, what does 106 say? 106 is, in one sense, utilized also in civil cases, that look, if you are the repository of a particular knowledge, it's peculiar to you, and only you would know it, then it's unfair to put the other side to the burden of proving that fact which is in your mind or in your head. The burden must shift to you to discharge the knowledge which is a part of your special knowledge. Right? The question is, can this section be used for the purpose of shifting a burden which lies upon the prosecution in a criminal trial upon an accused person? And there the courts have said nothing doing. No part of the ingredient of an offense can the accused be called upon to disprove, because it is incumbent upon the prosecution to prove every single fact, that constitutes the ingredient of the offense. Mark the word ingredient of the offense, because as the judgments say, that look, otherwise the best person to know whether A has murdered B or not is A. So therefore shift the burden on him and ask him to explain whether he's killed A or not. So therefore they say nothing doing. In a criminal trial, you cannot shift the ingredient of a criminal offense upon the accused person. That never moves, and Section 106 doesn't come into play. But where does it come into play? And there's an interesting case in the citation that I've given you. Facts were like this, that it was proved that the accused person was last seen in the company of the deceased. That fact had been established. Now, whether when the accused person left the deceased was alive or not, was a fact which was specially within his knowledge. So therefore, this was a case where they were trying to establish a case of murder against the accused on the basis of circumstantial evidence. And there the Supreme Court held that whether when he left the deceased, whether the deceased was alive or not, only he would know. It is within his special knowledge. So therefore, to that extent, that burden of whether he left him alive or not, that shifted to him under the provisions of Section 106. And if he gave an unsatisfactory explanation, this is important. If he gave an unsatisfactory explanation as to whether he left the deceased alive or not, when he left the deceased he was alive or not, that is a circumstance which can be taken into account as a link in the circumstances if you're intending to establish his guilt by circumstantial evidence. So this is the importance of this. And 106, therefore, in a criminal trial has to be utilized very, very selectively, so that any one fact, and that fact cannot be a fact which relates to the essential ingredient of the offense. It's a fact which is a circumstance which if is in his special knowledge and he fails to explain it, then the court can say, well, that is another circumstance in the chain of circumstances, and therefore it could go home to establish his guilt if it's a case of circumstantial evidence. This is how one must understand the provisions of Section 106. It doesn't shift the burden of the ingredient of the offense on the accused, but if a special fact is within his knowledge, he must explain it on the pain of having an adverse finding against him as far as that fact is concerned. Then sections 107 to 114A raise certain presumptions. And these are very, very elementary. In that sense, it's worth. Now, for instance, if the burden of proving the death of a person known to have been alive within the last 30 years is upon the person who claims that he is dead. So if that's an issue, whether a person is alive or dead, and it is brought on record that in the last 30 years he was alive, then the burden of proving that he is dead is upon the person who wants to establish that he is dead. Section 108 is exactly the converse, which says that if a person wants to prove that a person is alive, and that's the point at issue, whether a person is alive or not, and that person has not been seen or heard of by those persons, by his kin, who would have known whether he was alive or dead, then the person who claims he's alive must prove that he is alive. So it's exactly the converse. So for instance, for 7 years, the next of kin or the relatives or good friends of the person have never seen him, then the person who says no, notwithstanding that fact he's alive, must prove that he is alive. Then section 109 relates to the burden of proof as to relationships. For instance, if it is proved that there is a relationship of partners between two people having a partnership, that they're related to each other as partners, or of landlord and tenant, or of principal and agent. So if these facts are established, then anyone who wants to prove the contrary, that there is no partnership, there is no landlord-tenant relationship, is on that person who wants to disprove that fact, if it has been proved. Then section 110 says that the ownership, a burden of proving ownership of the property. An illustration which I've given you, if a person is in occupation or possession of a property, it is presumed that he is the owner, and anyone who says he is not the owner must prove the converse. Then section 111A relates to certain offense. I won't deal with that. Then section 112 is birth during the marriage is conclusive proof of the legitimacy of the child. So if a person is born during wedlock or within 280 days of the dissolution of the marriage, then it is conclusive proof that he is a legitimate child born out of wedlock and not illegitimate. So if the marriage, let's say, was dissolved on day 1 or day 2, and within 280 days a child is born to that, then it is a conclusive proof that he is a legitimate child. Then section 113 deals with cessation of territories. I won't deal with that. Then section 113A deals with presumption as to the abatement of suicide. Now these are new additions which say that these are again as a result of the insertion of section 498A in the Indian Penal Code, which says that if a person is charged with the abatement of suicide of another person, and it is proved, let's say of a woman, and it is proved that in the 7 years prior to that, she had been treated cruelly, then the presumption is the court shall presume that the person, that the suicide was abated by the husband or by the relative of the husband. Similarly, 113A deals with presumption as to dowry. Now again, if just before a dowry death, a person the wife or the woman has been treated cruelly, then it will be presumed that the dowry death has been caused by the person or his relative. Then section 114 deals with certain general presumptions, namely regard being had to the natural course of human conduct, etc., etc. And these are presumptions which are not heavy, but the court may take notice of these facts, that in the normal course of private and public conduct, etc., records are properly maintained, etc., and all that. And section 114A deals with the presumption as to the absence of consent in a case of rape. Now, for instance, if a person is charged with rape, and in the course of the evidence, the woman says that she did not give her consent, then the court shall presume that the offense took place without the consent and it's an offense of rape. So these are certain presumptions that arise in the course of criminal trials. Now come to the principle of promissory estoppel. Promissory estoppel is enshrined in section 115 of the Evidence Act. And it's first of all, one must note that promissory estoppel is a rule of evidence. It has subsequently evolved into a rule of equity, but it's basically a rule of evidence. And may I just read section 115 for you for the benefit of it? It's estoppel. When one person has, by his declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative shall be allowed in any suit or proceedings between himself and such other person or his representative to deny the truth of that thing. It's a rule of evidence, first of all, one must understand. It is this, that if a statement is made, if a representation is made, and it is made with the intention that it should be believed, and the person to whom it is made believes that to be so and acts upon that belief, then the person making the promise cannot claim any right of his flowing from a relationship. Now, this doesn't apply to contract, it applies to another relationship. Let me give you an instance of how this would apply. Let's suppose an employer tells his employee, look, you needn't, everyone else, the office hours are 9:30 to 5:30 or 9:30 to 6:30. But in your case, I'll make an exception. You may come when you like. You may come an hour, 2 hours late, as long as you make up the pendency of the work at your own time, either from home or by sitting late in the office. Let's suppose this is the understanding, or this is the assurance given by him to one of his employees. And the employee, believing in that, comes at his own time. He comes at 11:30, comes at 12, but complies with the rest of it and does it. Now, subsequently, the employer turns turtle and wants to terminate his employment on the grounds that he doesn't follow the regular timings that the other employees do, and that is infusing indiscipline in the organization. Then the doctrine of estoppel will kick in and say, no, he is perfectly entitled to defend himself by saying that you made the representation to me that my timings are different from the others, and therefore acting on it, I have therefore decided to come late, and it can't be a ground for termination of my employment. So he can use that as a defense to deny the employer claiming the benefits of claiming any rights that arises by virtue of that employment, by virtue of the terms of employment. So this is how it operates. Now, estoppel has evolved into a magnificent principle of equity. And in this regard, I would suggest, as students of the law, that there are 4 judgments which I have culled out, and I am going to give you the judgments. But the important one is the last judgment, which was decided in April 2020, just recently, in fact, just before the lockdown. And I'll give you that citation. But the 4 judgments and the other judgments which I'm discussing are discussed in this last judgment with the citations, so I won't give you. But the 4 judgments, just by name, are: the first one is the case of Anglo-Afghan. It's a judgment of 1980. Then the second judgment is a case of Motilal Padampat Sugar Mills versus, I think, state of UP or Madhya Pradesh. Then the third one is the case of Kanishka Trading. And the fourth one is, this is the citation that you must take down, because this discusses all these, and this is how the principle is laid down. It says, Union of India and another versus VVF Limited and another. This is reported in 2020 Supreme Court cases online, that page 378. It's worth reading, because this sums up the totality of the principle of promissory estoppel and discusses all these various judgments. Now, let me come back to the first case. In the case of Anglo-Afghan and in the case of MP Sugar Mills, what had happened was the government had made certain promises by way of circulars and notifications. In the case of Anglo-Afghan, they said that an importer of goods would be entitled to a concessional rate of import duty, provided those goods were then converted into, I think, woolen shawls and sent back to Afghanistan. This was it. And they said that you would be entitled to this benefit for a certain duration. Before the duration was over, this notification was rescinded by the government, and they denied him this benefit. Matter went to the Supreme Court, and the Supreme Court said no. This was a representation made by the government upon which the person has acted. He believed it to be true. He has altered his position to his detriment, and therefore the government cannot unilaterally now take away that representation or the effect of that notification. It is bound to compensate him and entitle him to the benefits of the import duty exemption, which he was entitled to. So this is how this was laid down. Now, they said 2 or 3 important things in that judgment, which were then amplified by Justice Bhagwati in MP Sugar Mills case. And MP Sugar Mills also was a similar situation where a promise was given to industrialists to set up their units for the purpose of improving production. They said you set up your units in certain backward areas in Madhya Pradesh, I think it was. And for a period of 3 to 5 years, there would be an exemption of sales tax. Again, halfway through that period, which was assured, many people, many industrialists believing in this representation, set up industries, employed people, took bank loans, etc. But halfway through that, this benefit was denied to them. In both these cases, the Supreme Court said, this is really with a view to promote honesty. And so that people have faith in the government that which makes promises, we will bind the government. Arguments were given of executive expediency, etc. And the court said nothing doing. The court said that, look, expediency is one thing. Unless the government is in a position to show that there is an overriding public interest, which compels it to withdraw the concessions given to it, they will be bound by the promises made by them. Now, I'll tell you what the importance of this judgment, especially MP Sugar Mills, is. Traditionally, this concept is a 100-year-old concept, namely the concept of estoppel and promissory estoppel, and comes from a series of English judgments. The High Trees case is the most significant one. It's a declaration of the law by Lord Denning. But in England, the approach is a little more conservative. They discuss the doctrine of promissory estoppel, and they actually say that promissory estoppel is really a misnomer. It's a misnomer. It neither arises out of a contract nor arises out of the principle of estoppel, because principle of estoppel, as I told you, is a principle which is a principle of evidence. But nonetheless, they said that evidence at the equitable principles come in. So what the English court said was that promissory estoppel can be used as a defense in a case by a person against whom certain rights are being claimed in the wake of promises which run against those, the manner in which the rights were to be claimed by him. But MP Sugar Mills said that no, there is no good reason why the doctrine of promissory estoppel should only be confined to a defense. In fact, they said that the doctrine of promissory estoppel must also be allowed, must also enable a person to actually found a cause of action and to actually claim damages from the government or any person who has made promises if damages as a result ensues to him. So therefore, the Indian courts, the Indian Supreme Court, took a strident stand, although of course, the seed of whether it operates as not only as the word was, it's not only a shield, but also a sword. The seeds were laid down by Lord Denning in his judgment, but it still was, the doctrine of promissory estoppel was only confined to defense and not to attack. But the Indian court said, no, it can constitute a cause of action. So therefore, if a person is hurt, or if a person is harmed by virtue of a withdrawal of a promise which is made by the government, or for that matter by any other person, he can sue on that. He can sue on the withdrawal of those representation, and he can actually found a claim. This therefore has gone ahead of this. Now, this particular principle has taken a bit of a hit in the case of Kanishka traders. They said that the case in Anglo-Afghan and MP Sugar Mills were clear-cut. There was a representation, there was a notification, people acted on it and operated or acted on it to their detriment, and therefore they could not be put to a disadvantage. Kanishka trading, also, there was a general circular which had been issued by the government saying that under the Excise or Customs Act, certain benefits would be given to a person if they followed certain norms, etc. But it was a general notification. And halfway through, that notification was substituted by another notification which rescinded the original benefits which had been given. This matter also went to court, and then Kanishka traders, they said, no, look, that's not so. Because if a government or if the executive has the right to promulgate a notification and confer benefits, surely it also has the right to rescind that notification or rescind the benefits of that notification by another notification. So it's not a blanket rule. And therefore, if a general permission is given, that general permission can be altered depending upon the change of circumstances. This is what Kanishka held. And Kanishka trading really then becomes the leading case as far as the exceptions to the principle of promissory estoppel are concerned. And that now has been accepted. And in this latest judgment, which I cited to you, there again, you see, there the facts were, bare facts were as follows. The bare facts were that the government of Gujarat said, this was during the earthquake in Kutch, and they wanted to incentivize people from, encouraging setting up industries or whatever, or getting into certain type of production and hiring people, because the people had been devastated as a result of the Kutch earthquake. And they said that on the production of goods, certain goods that they would make, they would get a certain refund of excise duty on that, or of the goods manufactured by them. They would be entitled to a refund of that excise duty. Subsequently, an amendment was brought about which said that, look, it's not that you will be entitled to the entire refund of the goods manufactured. You will be entitled to only 34% of the refund, because this 34%, what we intended to say was that the refund will be on the value add of the goods and not the total value of the goods, but on any other component that adds value to the goods which have been brought into existence. So this is what they said. Now, this matter went to court. And of course, there were certain other states also involved. So this went in the form of a PIL. And the Supreme Court finally, tracing this entire evolution of the principle of doctrine of promissory estoppel, it went on to say that, look, this doctrine of promissory estoppel cannot be overstated, and it is subject to 5 caveats, and I'll just mention. They said, first of all, the doctrine of promissory estoppel is a balance between equity and public interest. That's number one. Then it said that promissory estoppel must yield to equitable principles. Then thirdly, they said that the representation by a government may be changed in the public interest. That's the third principle. Fourth, they said that public interest must override any consideration of profit or loss caused to an individual. And finally, they said that the doctrine of promissory estoppel is not a hard and fast rule. So, of course, then they went on certain other aspects of that case also to say that the amendment which had been brought about, which reduced the refund to 34%, was really clarificatory in nature. And because it was clarificatory in nature, it didn't operate, it could operate retrospectively, because that was always known to be the law. But be that as it may, this principle of promissory estoppel, therefore, this I think pretty much seems to be the last word on the subject, that this is how the courts will view it. So therefore, it started off as a first of all, estoppel is a principle of evidence. Then it, in combination with equity, it became a principle by which you could found a cause of action as far as the Indian law is concerned. And then come the exceptions to that, as was started off by Kanishka trading, and in this final judgment that I've given to you. Now, question is, does this principle of promissory estoppel apply in criminal cases? This raises certain interesting issues. And then I'll just give you a judgment of this. If you just make note of these two judgments, I'll give you the citation. One is AIR 1956, page 415, and the other is 1965, AIR 1965, Supreme Court, page 87. The first one is the case of Pritam Singh, and the second is Manipur administration versus whatever, unpronounceable name. Now, they said question was whether the principle of promissory estoppel applies in criminal cases. Now, remember one thing. Promissory estoppel, or what is known as issue estoppel more appropriately in the case of criminal cases, issue estoppel or res judicata is applicable, and this is not to be confused with double jeopardy, that no person shall be punished for the same offense twice. Take a case like this, and this is what has been decided by these judgments. Take a case like this, that in fact, in one of the cases, a person was charged with an offense under section 188 of the Indian Penal Code, namely, in violation of a declaration or a promulgation of an order. There was an order which was promulgated, which said under section 144 of the Criminal Procedure Code that you couldn't have an assembly of larger than X number of people. So this person was charged with violating that promulgation. And now in that, eventually, he was acquitted on the ground that he was not found to be a part of that assembly. So he got an acquittal. Subsequently, the same person was charged under section 338 of the Indian Penal Code. The first question came up is that I can't be charged. I've been acquitted of an assembly, and in respect to the same facts, you can't charge me with 338. The court said, no, look, these two are different. You can be charged for a different offense. So that now 338 is causing grievous hurt to another by rash and negligent act, etc. But what was essential for them to prove the second charge was that in fact, the hurt that he had caused was as a part of an assembly which had gathered together and thrown some bricks, etc., at, I think at some police or whatever it was. Now, that he was not a part of the assembly had been found in his favor in the previous trial, and therefore the Supreme Court held that you cannot, that fact is closed, and no evidence can be received in a separate trial, in a subsequent trial, although under a different charge. You cannot now receive evidence to show that he was a part of the assembly, because that he was not a part of the assembly has been conclusively established in his favor. And so therefore they applied the doctrine of issue estoppel, that in criminal trials, although you may be tried for a separate offense, but if a particular issue has been decided in favor of an accused in a previous trial, then no evidence may be received in respect of that fact in the subsequent trial. This is where the principle of promissory estoppel or issue estoppel applies in criminal cases. Finally, the rule of estoppel is also, then section 116 also applies in the situation of landlord and tenant, which says that if a tenant is inducted into the premises and acknowledges someone as his landlord at the beginning of the tenancy, then he is precluded, he is estopped from denying that the landlord, that the person is not the landlord. And the same thing also applies in 117, where the acceptor of a bill of exchange cannot deny that the drawer of the check had actually had the authority to issue that bill of exchange. Now, these are principles. Again, I'll give you one more judgment as far as the section 116 is concerned. It's a fairly recent judgment. It's a case of Bismillah BE versus Majid Shah. It's 2017, page, that's 2 Supreme Court cases, page 274. So therefore, the principle of estoppel applies in this particular manner into criminal cases. So this more or less concludes. Now, all that I want to say in summation, in conclusion, is this, that rules of evidence, after all, this is the discipline of the court. When it receives evidence, all that evidence comes before it, and it must then apply its mind as to how to interpret that evidence. Of course, in order that it constitutes evidence, as I had spoken about in my first webinar, in order that it should constitute evidence in the first place, it must pass muster. It must be in accordance with the other provisions of the Evidence Act. It must, for instance, be relevant. It cannot be hearsay. It cannot fly in the face of documentary evidence. So all those rules have to be kept in mind. But once the evidence is before a judge, then it is his duty to sift that evidence, understand it, and see which person is entitled to succeed on whether, by the rules of evidence and by the rules of burdens, the burden, whose burden it is, whether he has discharged his burden or not. This is a discipline which comes with years and years of judicial experience. And what can I say? Therefore, I started off by saying it's really, in that sense, an unenviable task of a judge, especially when, of course, uh, again, which I told you, that oratory makes a big difference, how it is done. But the discipline is so clean and so neat that if one follows it, your chances are that you will hit upon the right judgment. Well, I have finished with that. If I'm willing to take questions.
If anyone has any questions, you can put that in the chat box. So there are no questions as of now. So we can conclude our webinar here.
Sure.
Thank you, sir, for enlightening us on today's topic. It was indeed a very informative session for all of us. And I'm sure to have many more sessions by you in the near future. Secondly, I would also like to thank all the participants, those who all attended today's webinar. Stay safe, stay healthy. Jai Hind.
Thank you.
Thank you, sir.